not heard appeal in the matter of the Commissioners for HMRC and applicants in the Post-Prudential Closure Notice Applications Group, Litigations and another.
Good morning, my lords, my lady. Before I start, can I just say that you should have been handed up a one-page document.
Yes.
Which is agreed between the parties as to when the various lead appellants and applicants made their applications or brought their appeals to the tribunal.
That's very helpful, thank you. So that confirms that all of them were commenced prior to the 31st December 2020.
Yes, yeah.
Thank you.
That's the lead claimants. Obviously, we don't know about the
Sure.
100 followers. So where I had reached in the chronology was FII, the first Court of Appeal decision in FII, which is an appeal from Mr. Justice Henderson's decision. And that's behind tab 27 in bundle 2, and it begins on page 486. And my learned friend is taking you to some passages from this. I'm not going to go back to them. What I wanted to take you to was a passage in relation to the Section 33 Taxes Management Act argument. And that's begins on page 582. The actual section.
Sorry, you said 582. Do you mean 482?
No, I mean page 582, paragraph 250. Oh, right.
Sorry, I thought you were in the first instance decision.
No,
this
no,
is the
I'm in
appeal.
the Court of Appeal.
Ah, right, yes. Okay, that's my fault. Thank you.
Court of Appeal. The issue 23 actually begins on page 579, but up until then they've been setting out the provisions.
Yep.
So, and it's particularly, so paragraph 250, it makes the point that section 33, which is the predecessor to paragraph 51, the old paragraph 51, it applied, I think it's right, both to income tax and corporation tax.
So just to clarify, when you say the old 51, you mean the one that we're concerned with?
Yes, I mean the one we're concerned with.
Before April 2010.
Exactly, yes.
And section 33 covered both corporation tax and income tax until it was separated.
In 1998.
Yes,
yes.
Which is where paragraph 51 comes in.
Exactly.
So do you say that anything we're looking at here in relation to paragraph 33 is equally applicable?
Can I just make clear? The point I'm trying to deal with here is a response to what the claimants have said about the revenue's attitude to section what is now paragraph 50 or was paragraph 51, and I'm explaining why there was an issue as to section 33 of the Taxes Management Act at that time, on the basis of the arguments that were being put and the case that was being put on each side at that time, which obviously changed after 2012 when we had the second reference and we had the introduction of the foreign nominal rate. But at this point, as I said yesterday, the argument was between the revenue saying the system in relation to controlled dividends was fine, was compatible with EU law, and the revenues, and the taxpayers saying, the claimants saying, no, it's completely unlawful, and therefore the charge is unlawful. Essentially, in domestic terms, there should be an exemption, or the charge should be disapplied. So that was the argument that was being put, and so you can see in paragraph 251, the Court of Appeal says the question of the application of section 33 only arises on a hypothetical basis, namely that following a reference made pursuant to our decision on issue 1, the ECJ makes a ruling pursuant to our decision on issue 1 above that a dual exemption credit system for relieving double taxation is not precluded by community law, provided that not only the nominal rates of tax, but also the effective rates of tax paid by the non-resident and resident companies distributing the relevant income are the same. So what they're saying there is if the ECJ were to decide in favour of the claimants, because that was the claimant's argument, then this issue arises because the claimants would then be in a position to say the charge is unlawful and therefore we paid tax by reason of a mistake in a return, because we returned the income as taxable, and in fact it wasn't taxable, it was exempt. So that's the basis of the argument, and what the Revenue was saying was Section 33 ousts common law claims. Now, there had been a decision of the Court of Appeal prior to this in the context of domestic claims, so there was no EU element in it, a case called Monroe, where the Court of Appeal had decided that Section 33 did oust common law claims.
So that's the case referred to at paragraph 254.
Yes, that's right. Yeah, that's Monroe. And the question was, did that apply equally in the context of EU law claims? And the Court of Appeal decided that it did. One of the problems that arose was that there was a provision in Section 33, and we'll come back to that when we look at the business brief, which there is also in the old version of paragraph 51, and I think also in the new version, although it's been amended, which said, and this is paragraph 261 of the decision, it said that you essentially, if the profits had been computed on the basis of the prevailing practice at the time, then you couldn't recover. And there had been a decision of the European Court previous to this, which said that a provision like that is contrary to European law. It doesn't provide an effective remedy. The state can't say you can't recover your unlawfully charged tax because the prevailing practice in the past was that it wasn't unlawful, for instance. So the problem with Section 33 was what they mentioned here, Section 33, 2 capital A, little a. And the Court of Appeal's solution to that was to say, well, that provision is simply disapplied in EU law situations. And having disapplied it, we can then Section 33 is an exclusive remedy, and that's paragraph 268 is the conclusion that they come to. Now, in fact, in this GLO, it wasn't a very important issue because there was, my Lord, Sir Launcelot Henderson may recall that there was very, very little D5 tax paid by BAT or other claimants. Very, very little because of the ACT system and because of expenses and reliefs. It was measured in hundreds of thousands, whereas the claims were measured in hundreds of millions. But it was very important in the parallel Prudential litigation that we are dealing with, because most of the claim, a lot of the claims are D5 tax claims. So what then happened was that this was appealed to the Supreme Court, and the Supreme Court took the opposite view. They said, well, it's a bit strange to say that you disapply part of the provision and then oust common law claims. The more obvious solution is just it doesn't oust common law claims, and that's what the Supreme Court decided in the end. But at this stage we had the Court of Appeal decision, which was that Section 33 applied, but with the removal of the prevailing practice provision.
All right, but what are you relying on in this?
So, well, first of all, it's going to explain what's been said in the business brief, which the claimants rely on to some extent as being significant. I'm just going to come briefly to that. But it also, the point here is not that the Revenue are promoting Section 33 as a method of recovering tax, which is the way it's been portrayed. We weren't saying you should bring claims under Section 33 or subsequently Para 51. what we were saying was, if your claim is that the tax is not due because there is a disapplication or exemption, then that would be a situation that Section 33 would apply to, and therefore it would oust the claims for corporation tax. That was the position we were taking. Of course, the position became very different. And this didn't apply, I think this point is made here, this didn't apply to ACT, because ACT was not a tax that was recoverable under Section 33.
So at this
So
stage,
the bulk of the claims, it didn't apply to.
Stage, consistent with what the Supreme Court, or against what the Supreme Court subsequently held, HMRC's position was that it did oust common law claims.
Because the common law claims were on the basis of, not on the basis of a double tax credit, and the FNR, because that hadn't been invented yet, but they were on the basis of a complete disapplication of the charge.
I'm a little puzzled as to why you're so concerned to explain the revenues then position, because as I commented to Mr. Bremner, we have no issue before us as to legitimate expectation or estoppel or anything like that, to which the revenues position might be legally relevant. Seems to be, as I observed to him, a pure jury point with no legal relevance at all. And in any event, what surely matters is what was the actual decision of the court. And what we see from paragraph 268 is that having adopted a conforming construction of Section 33, the Court of Appeal at that stage said, well, it's an exclusive remedy. And as you say, we now know that that was wrong. So that's the history. But you know, where does it take us?
Well, in my submission, it takes us nowhere. I agree. I rather feel that I have to deal with it since it's
perhaps you
an
could
important part of my learner
deal with it quickly.
I'm dealing with it quickly, yes. So that's all I need to say about that, and then I can deal with the business brief. Before I just do that, can I take you to para 51, the new what happened in 2010, which was a substitution of a new para 51, just briefly, so that you've got the complete picture. That's at tab 12 in bundle 1. And can I just draw, so what happened was, this provision, the para 51 and the following 51A, etc., which are all part of it, was introduced and became law, was part of the Finance Act 2009. However, it didn't take effect until 1st April 2010, and that's so it became law in the middle of 2009. It didn't take effect until 1st April 2010, and that was the transitional period I was talking about. It gave people a chance to.
Forgive me for a completely irrelevant question, but why the 1st of April? Seems quite odd to me as a novice that you would bring into force a new tax provision on the 1st of April. But there we go.
Well, I think often company.
It's financial year.
Financial year, yes. It's from 1st of April.
It's the government's financial year.
Yes, yes.
Right, okay. I'm grateful.
And tax changes tend to take effect.
Yes.
I'm grateful for the explanation. Yes, thank you.
It's April Fool's Day as well. Be part of it. Can I just draw attention to the form of paragraph 51, because I think that this has an importance in the arguments we're going to come to. Paragraph 51 is originally, which is on the previous tab, only applied where there was tax paid under assessment was excessive by reason of some mistake in a return. So it's quite, we would submit, quite limited in that way. The new paragraph 51, though, was wider. It applied where a person has paid an amount of tax, paid an amount by way of tax, but believes the tax was not due. So it doesn't have to be because of a mistake in a return.
Well, again, I'm grateful to be educated, but what's the relevance? Because as I understand it, we are required to apply the version at tab 11, not the version at tab 12.
Yes, but it will be, and you may say this is again also irrelevant, but it may be part of the argument as to what paragraph 51 in tab 11 means. As to
Can't construe it by reference to a later version.
What I'm explaining though is why in the original paragraph 51 it doesn't refer to not making a claim as being outside. If you remember, my friend made this point that in the new version, both a mistake in a claim and a mistake consisting of failing to make a claim are expressly taken out in par 51A to case A, little a and b. And my learned friend made the point, well, they did that there, they don't have that in para 51. And the explanation for that is para 51 is actually limited to mistakes in a claim, in return. And not making a claim in a return is not a mistake in a return. That's what we submit. I'll come back to that when we deal with para 51. Yeah. But the broad intention we would submit is that claims are outside para 51 and elections, and they are dealt with by the specific provisions that deal with claims, which have their own regime for making claims, amending claims, inquiring into claims, etc. The reason for the transitional provision is because of 51(6) in the new provision, which introduces the ouster, which says that you cannot bring claims after that date, other than under the Taxes Act. So it prevents common law claims being made after that date. And I think also possibly because the limitation period, the period was cut from 6 years to 4 years at the same time, which would also maybe have a European law theoretical problem. So this was a rewrite in a different form of the provisions for recovering tax under the statutory regime, and was quite important outside European law, just for taxpayers generally. And that's the reason for the business brief, which is in tab 40 of the joint supplementary bundle. And I will deal with this quickly. I can. What the business brief was doing was, first of all, giving some information about the new overpayment relief. So they say at the top, publicising the introduction of overpayment relief, and secondly, publicising and explaining that the revenue will apply the Court of Appeal decision concerning prevailing practice in relation to EU law claims generally. But making it very clear in the last sentence, right at the bottom of the page, other conditions for error, mistake relief and overpayment claims, such as time limits, only still need to be met in all cases. So this is not an invitation, as my learned friend suggests, to bring paragraph 51 claims in all circumstances. It's simply explaining the new regime, which is relevant outside EU law, obviously, and generally, and making it clear that the revenue will apply what the Court of Appeal said in relation to EU law claims, all EU law claims.
And just on that, just because it's relevant elsewhere, that point about prevailing practice, the revenue continues to accept, as I understand it, that provision should effectively be disapplied.
Yes, and what happened after 2010, I think a year or two later, is that the provision, the new para 51 was actually amended, or there was an amendment brought in to specifically say that it didn't apply.
Okay, but I'm concerned.
But at the time we're dealing with, yes, of course.
There's no argument upon that point.
No, that's right. So then, can I take you to the next case in the chronology, which is the Supreme Court decision in FII. the first Supreme Court decision. And the only part of that I need to take you to is what Lord Sumption said, because my learned friend prayed that this in aid. This is Bundle 2, tab 28. And it begins on page 675. And it is, first of all, paragraph 176, which is on page 675. I'm sorry, it doesn't begin on 675, it begins on 603. 675. And this was responding to a paradoxical argument raised by the claimants, which was that there was no claim in Woolwich. And I think, as I explained yesterday, the tactical reasons for this was that they wanted to exclude the Woolwich claims so that they didn't have the argument that there was an effective remedy. Well, the argument was a Woolwich claim couldn't be brought because, applying the conforming interpretation, there was no unlawful charge. But what Lord Sumption was explaining here was that in the context of the Woolwich claim, which is a common law claim, there was an unlawful charge, despite the conforming interpretation. And that's what he explains in paragraph 176. He says, just at letter F, the rule as the House of Lords formulated in Woolwich Equitable is in large measure a response to realities of the relationship between the state and the citizen in the area of tax. The fact as a matter of strict legal doctrine, a statute turns out always to have meant something different from what it appeared to say is irrelevant to the realities of power if it was plain at the relevant time that the tax authorities would enforce the law as it was then appeared to be. Strictly speaking, in Woolwich itself, there were no unlawful regulations because, being ultra vires enabling act, they were and always had been a nullity. But that did not stop Woolwich from recovering. So this is a point made specifically in relation to the Woolwich claim in common law. He's not saying that when you apply statutory provisions, such as we've been arguing about in this case, that you don't apply a conforming, you don't respect the conforming interpretation. And Lord Walker made a similar points at paragraph 82 to 83, my learned friend took you to.
Perhaps a good example of sort of pragmatic common sense triumphing over a point which at first blush looks as though it has some force as an economic logic.
Yes, well, it would have force if it was a statutory provision, because it would apply. But the point he's making here, this is not a statutory provision we're dealing with. This is a common law claim which is based on, as I said, the realities of power.
Yes, I agree with that. Yes.
And of course, his point at the end is that, you know, if this was right, Woolwich wouldn't have recovered. So it seems a really powerful point. So that's what I say about that. It's not relevant to what we're dealing with in this appeal. And then we come on to the second reference, which came back after that. It's bundle 6, tab 63. And I think my learned friend has already made it clear that there was a disagreement, as you have seen in the domestic courts, as to what the question meant, which had been referred back by the European Court in the first reference. And my Lord and Lord Justice Etherton in the Court of Appeal thought it meant one thing which favoured the claimants. Lady Justice Arden, Lord Justice Stanley Burnton, I think, thought it meant the opposite, the other thing which favoured the taxpayer. When it came to the European Court, in fact, I think you've seen, the Advocate General thought, as a matter of construction of the judgment or understanding the judgment, that we were right essentially. However, he thought that the whole thing was misconceived. he didn't agree with the court's approach at all. And further, he didn't agree with the approach being put forward by the Commission, which is what the court subsequently adopted. I think he described as intellectually incoherent at one point. He had 4 reasons why he thought it was wrong. So all I get from that is that clearly there's not confusion, but there clearly is disagreement, both in the domestic courts about what the judgment meant, but also in the European Court itself. And that was why I made the submission yesterday, that if there was a problem here of legal uncertainty or difficulties, it was caused, in my submission, entirely by the decisions of the European Court, whatever you think about them. And there's nothing that was done in the domestic courts which breaches in any remote way principles of legal certainty or principles of effectiveness. That's my submission, that the domestic courts acted entirely normally and correctly. There were, of course, appeals, but that's a part of the normal system. You can't say it creates uncertainty that there were appeals. And
on the contrary, it's really an aspect of effectiveness, that you have a right to appeal against something you think is wrong.
Exactly. But you can't complain, well, one court said this and another higher court said something else. And now I need to look at this question 1 in the context of my learned friend's argument yesterday, that the effect of this, as I understand it, is to deem there to have been foreign tax paid, further higher amount of foreign tax paid. If you remember, he said, well, because of that, you then feed that into section 806(2). So it's a critical part of his argument in a number of issues, that the effect of this is that there is foreign tax paid. He also made the point that although it mentions the credit only being up to the amount of UK tax in an earlier part of the decision, in paragraph 39, when you come to the actual decision on foreign nominal rates, there's no mention of that. And that is in support of his argument that you can have a credit which goes beyond the amount of UK tax charged on the dividend. And that credit, that further amount can then be used under UFT or whatever. If you recall, that was one of his arguments. In my submission, this is misconceived. What you have to understand is what the court is talking about in question 1. It's talking about the imputation system and comparing it to an exemption system. And both of these are designed to eliminate double taxation of the same income. So there are 2 types of normally recognized 2 types of double taxation. One is called juridical double taxation, which is where the same taxpayer is taxed twice on the same income. And that occurs in this context in relation to withholding tax. Because the withholding tax charge is a charge on the recipient, although it's collected by way of deduction. And the recipient therefore is charged twice, once by the foreign state by withholding tax charge, twice, the second time by the UK in this context on the dividend. So that's juridical. And then there is economic double taxation, which is what we're really concentrating on in this case, which is where the same profits or income are taxed twice, but in the hands of different taxpayers. So you have a foreign company, let's taking a simple example where there's only 2 companies. The foreign company makes profits and pays tax abroad in, say, Germany. It then pays a dividend to the UK out of those profits, and that's taxed in the UK. So the profits are being taxed twice. And the credit that's given for underlying tax is intended to negate that double taxation. That's the purpose of it. That's the purpose, and that's the imputation system. It doesn't go any wider than that. It can't go any wider than that because it's dealing with double taxation of the same income. And that's why you cannot get a credit that is higher than the amount of tax charged in the UK. Because once you reach the amount of tax charged in the UK, there's no tax charge in the UK, there is no double taxation. And you don't go further and say, well, there's more of a credit there available, we'll set it against other income. Because the other income is not being doubly taxed. So that's the,
Yes,
this
you
is
have
this
to
is a
accept-
description of the imputation system,
You
sorry.
have to accept a partial exception for that, as found in Salon and SC3, that if the UK tax is eliminated by management expenses or group relief.
Yes,
But that's, I
But that's
think you would
different,
say
yeah.
a partial exception to.
but it's also the problem is there that you're losing the credit because of the order in which
Right.
the domestic system allows the reliefs. That's the problem there. So you're not being able to get the credit and the management expenses because these are two. The way the court looked at it, these are two reliefs that you're entitled to. One is to relieve the double taxation up to the amount of the UK tax, and the other one is a management expense which you can set against
Thank you.
income generally. And Salonen, I think the rationale of Salonen is you shouldn't be. If the income had been exempt as a domestic income was, you wouldn't have lost the management expenses essentially, because you wouldn't have set them against the exempt income. You would have just used them somewhere else or carried them forward. That's the rationale. Yeah. But even in that case, it's only the credit is only up to the amount of the UK tax. And so paragraph 39 of this judgment in my submission is simply a description of the imputation system. It's not, it is saying this is all right because this is a description of the imputation system. It talks about the tax credit is at least equal to the amount paid in the state of the company making the distribution up to the limit of the tax charge in the member state of the company receiving the dividends. So that's an imputation system where you're allowing relief. And so when we then go to paragraph 49, sorry, paragraph 49 is dealing with the judgment. When we then go to paragraph 62.
Sorry, can you give me a page number?
Yes, 1905.
Thank you.
Where the court says, for the purpose of ensuring the cohesion of the tax system in question, national rules which took account in particular also under the imputation method of the nominal rate of tax to which the profits underlying the dividends paid have been subject would be appropriate for preventing economic double taxation of the distributed profits and ensuring the internal cohesion of the tax system while being less prejudicial to freedom of establishment and freedom of capital. So what they're referring to here is in the imputation system, under the imputation system, rather than getting a credit for the tax actually paid abroad, you get it for the nominal rate of tax. But still, under the imputation system, it would be limited to the amount of tax chargeable in the UK on the dividend. Otherwise, you'd be creating a different system, not an imputation system, not a system for relieving double taxation, but a system which went further than relieving double.
It's better than exemption, isn't it?
It's better than exemption, yes. Well, it's a
Excess credit.
but it's a different type of system. I mean, it's simply not doing the thing that imputation systems and exemptions are sent to do, which is to relieve double taxation of the income and the dividend. But yes, it would be more advantageous, but it would be a different system in my submission. So in my submission, paragraph 62 is consistent with, and does lead to the conclusion that it is limited, that the credit is limited to the amount of tax.
The reason I raised the point better than exemption is because the key challenge under European law is discriminating against foreign source dividends as compared to domestic dividends. So doesn't the argument go that the solution can't do more than eliminate that discrimination?
That's what it would be aiming for. I agree, my lady, that's the aim, not to go any further. It wouldn't be contrary to European law to go further.
No,
It's not contrary to European law to...
That's not my question. The point being argued against you is essentially that European law requires you
Yes,
to go
further.
and grant youth, for example, in relation to the FNR. That's the point I'm thinking
Yes.
about.
Yes, not...
And I know you're raising arguments about tax paid and so on, but I want to also think about it in the broader sense.
Yes. No, I agree. And the court would only go further if the only way of curing the discrimination or the restriction was to go a bit further and actually benefit foreign dividends. If it had to do that, then I guess it would perhaps in some cases do that. But it doesn't, it's not required to. I mean, it's not what it's aiming to do.
But is there not can you not say, therefore, that in construing how far, what modifications, if you like, we need to make to the UK legislation, we need to do what is required to eliminate the discrimination and not more?
Yes, but that put another way, that's what the court is doing. It's doing what's required and not more.
Yes.
So putting another way, that it would be very surprising construction or result of the judgment if it did go further. And it plainly doesn't, just on its terms. Yeah. But another point you perhaps we should make is that just looking at the judgment is that the court is not saying that the two things are the same. Exemption and credit at the foreign nominal rate. In fact, it goes out of its way to say in paragraph 64 that they might still produce different results. What it says is they're equivalent as far as European law is concerned. That's all they have to be, not the same. So it's not being said this credit is the same as exemption. In fact, it clearly isn't, because you might well have situations where the result is there is still tax payable in the UK even after you've applied the credit at the FNR. If the FNR is very low, for instance. So they're not saying these two things produce the same result or are the same. They're simply saying they're equivalent, sufficiently, they're equivalent and the EU law, and that's enough.
Well, I appreciate the point you're making, and in a sense, I don't have a problem with it, but I'm not sure that's strictly what the court is saying. What the court is saying is that they are both equally unobjectionable from the point of EU law.
Yeah.
The point being that what the court is recognising is that member states retain fiscal sovereignty, save insofar as that is incompatible with the treaty.
Yes, that's paragraph 64.
Exactly.
Yes. And essentially...
And so that's the whole point of what the court is doing in this case, is it's trying to reconcile two things which are plainly in tension. One is fiscal sovereignty of member states on the one hand, and on the other hand, non-discrimination, because that's prohibited by the treaty.
Yes, but it's recognised.
And it's you can for the shorthand purposes call that equivalent, but I think one needs to be careful with that word because it is a shorthand.
Yes, I think it may be what they, how they describe it, but yeah, the point I'm making is it's not the same, which is
That's the
seems to be what's
important
being
point,
suggested.
yes, yeah.
And one of the reasons it's not the same is because of the different tax rates in different jurisdictions. So if it happens that the tax rate is low in a jurisdiction, which some of them, remember we were dealing with that in FII, there were some where there was a low tax rate, you can end up with a tax charge in the UK when the UK tax charge is higher.
The existence of these different rates is just a feature of the lack of overall harmonisation, which is
Exactly, yes.
in this part of the legislative jungle.
Yes, and it varies from time to time. I mean, the UK corporation tax rates have been very high, 50%, I think, at some points in the past.
But they've become a sort of political
Well, the UK, like other member states of the EU, has exercised its fiscal sovereignty as it sees fit from time to time.
Exactly, as they all do.
So, where do we go next?
So, yeah, next we go to Prudential in the High Court. And that's bundle 3, tab 2, begins on page 712. It's tab 30, I think it's bundle 3, tab 30. 712. And again, my learned friend's taking you a lot of this already. I'm not going to go through all of that. Can I begin just to show you the passage that I was referring to yesterday about Haribo, page 736 to page 737, paragraphs 52 to 53. I'm not intending to read that, but that's where my lord came to his conclusions on Haribo and the significance of that case.
Yeah.
And then page 748. And this is paragraph 87, the conclusion on according to the claimant, it's the right way to take account of the nominal rate of tax in the source state to grant a tax credit for such a nominal rate, in addition to a credit for the actual underlying tax paid in respect of the dividend, up to a ceiling in each case of the full amount of the actual charge of corporation tax under case 5. And again, that's correct, obviously, in the sense the imputation system. The credits for the nominal rate of tax and the actual underlying tax are cumulative, but in combination they cannot do more than extinguish the case 5 charge. Thus, there is no question of any windfall for the claimants because any excess of the credits over the actual charge would not generate any right to payment of the excess from HMRC. And if the end result is virtually every case will be to extinguish the charge, that is neither surprising nor a cause for concern. On the contrary, it will merely illustrate how the exemption and imputation methods.
This is just stating the claimant's position.
Yes, but that is then accepted. Page, I was going to go on page 751. Paragraphs 95 and 96. He says, first thought, it might be thought the claimant's analysis of the invalidity under EU law is unduly complex. Sorry, I took it to you because otherwise you might not, it might not make much sense to, and also likely to produce too much in the way of credit. One may feel intuitively that credit for underlying tax actually paid and credit at the nominal foreign rate ought to be alternatives. Something must have gone wrong if they're treated as cumulative. But the two types of credit are conceptually quite distinct. And the apparently excessive result of aggregating them can simply be remedied by treating them as alternatives, with credit to be granted for whichever amount is higher, up to the limit of the case 5 charge reduced by withholding tax. In the great majority of cases, credit at the nominal foreign rate will be higher than a credit for the underlying tax actually paid. But Mr. Anderson is able to satisfy me this is not invariably the case, particularly bearing in mind the widely varying systems of corporate taxation through the EU. I therefore conclude that the UK legislation would have been compliant with EU law if it provided for the grant of such a dual credit for portfolio dividends, the grant of the further credit for withholding tax is not in itself a requirement of EU law, as the decision in Salonen makes clear. But there can be no doubt in my judgment that credit for withholding tax must be granted as a matter of domestic law. And then he says he had no detailed argument. We've already read this passage, but he concluded that it should be dealt with first. And then, and I'm not going to take you through this because my learner friend already did, but just to draw attention, beginning on page 752 is a discussion of the question about conforming interpretation. And my lord makes the point in paragraph 100 at the end, that the question is conceptually important. Now, I'm not going to presume to say what my lord meant by that, but I suggest, since this is a judgment and I'm entitled to make a submission about it, I would suggest that what my lord was saying was that you are required, as a matter of legal, as a matter of law in the UK, if you can, to find a conforming interpretation of the legislation and apply it. And it's only if you cannot, it's not possible to find a conforming interpretation, that you go to this application. And so we have the conforming interpretation in paragraph well, I think really paragraphs 103, 104, 105. Where the primary submission in 105 was it should be disapplied, but that was not expressed with any enthusiasm. It's quite clear in my submission that what my lord was saying in this passage about conforming interpretation was not suggesting in any way that the effect of the conforming interpretation was to deem there to have been more tax paid in the foreign country, foreign state. The dual credit was for two different things. One was actual tax paid. The alternative was a credit computed, taking account of the FNR at the FNR. And those were two different things. Secondly, the conforming interpretation, my lord made the point that if there had been a conforming interpretation, there would have been a partial disapplication to take account of the fact that it's only up to the amount of the credit that the charge would be unlawful. Now, this is in a way irrelevant because there was a conforming interpretation and we don't get that far. But even if you had got that far, there would still involve a claim because you would need to know what the amount of the FNR was in order to decide on the disapplication. So whichever way you cut it, there would have to be a claim in relation to the FNR submission. But that doesn't matter because we know that there was a conforming interpretation and that's what has to be applied. Can I just take you at this point to a case that's mentioned in this passage, IDT. My learned friend took you to this. I just wanted to point out something about IDT, which I think is maybe quite important. It's tab 23, which I think is in bundle 1. This is a case, interestingly, in which the Court of Appeal applied a conforming interpretation at the instance of the revenue. The result of the conforming interpretation was that tax was imposed, which wouldn't have been imposed otherwise. This is a VAT case. And simply the point I get out of that is it just emphasises the fact that conforming interpretation is entirely neutral. It is the conforming interpretation following EU law. The results of that might be favour the taxpayer. In some cases, it might favour the revenue. It's not, as I think as my learner friend tried to suggest, part of the remedy in the sense that it's something that the taxpayer is relying on. And the court dealt with a couple of these points. On page 254, paragraph 109, and then something I think has gone slightly wrong with the paragraph numbering. So this version or something. There's paragraph 109, 110, 111. First of all, they say in paragraph 109, once it's determined that the court has a wide power to interpret legislation in light of the wording and purpose of the 6th Directive, no objective in principle to interpreting Schedule 10A to conform to the principles of the 6th Directive. The principal remaining objection to the application of mild leasing principles in this case is the principle of legal certainty. This is an important issue. I accept that under the principle of legal certainty, the person affected by the legislation must be able to foresee the manner which is to be applied, and I would also accept that must particularly be so with the legislation's financial consequences for him, such as a flow from the imposition of the requirement to account for VAT. A taxpayer has a legitimate expectation that this principle will be observed. Moreover, a taxpayer is entitled to structure his business so as to limit his liability to tax, to take advantage of any loopholes he can find. These principles can be found in the judgment of the Code of Justice. However, in the present case, it is well known that the provisions of VAT Act have to be interpreted in conformity with the 6th Directive, and the supply of telecommunication services constitutes a taxable supply. I therefore agree with the judge that the principle of legal certainty is not infringed. In addition, it's not an objection to the application of the mild leasing principle that may result in the imposition of civil liability, where such a liability would not otherwise have been imposed under domestic laws, for example, a case in the European Court, where the effect of interpreting Italian law in accordance with the directive on commercial agents was that a contract made by an agent who was not registered in accordance with the purely domestic provisions was enforceable and not void. This point was specifically made by Advocate General Jacobs. The Court of Justice reached the same conclusion, though it did not advert to the point. However, it distinguished the application of the mild leasing principle from the general principle that a directive cannot impose obligations on an individual. So I just wanted to point out that that was a position in IDT, rather unusually, perhaps. Can I then take you to the Court of Appeal in Prudential? And that's in Bundle 3, tab 34. And there are only 2 paragraphs that I need to look at in this decision. Page 882, paragraph 92. So page 18, the competing arguments are as follows. Prudential says the effect of the decision of the Court of Appeal in FII Court of Appeal in determining that an interpretation of 231 which conformed with EU law could and should be given to that provision, and the judge's declaration regarding the proper interpretation of section 231 made after the main judgment is that section 231 should be construed in such a way as to grant a tax credit for foreign source portfolio dividends of the amount needed to secure compliance with EU law. The effect of this is to create a modified FII system in relation to foreign portfolio dividends, in which the tax credit for foreign portfolio dividends will be treated as part of a franked investment income under Section 238 in the same way as payments of ACT. So it's not being treated as payment. My point is, they're not treating it as payments of ACT, they're treating it as part of the franked investment income in the same way as the payments. And are treated as part of the franked investment income under those provisions. So that was the argument that was being put, and that was what was accepted by the court at paragraph 109. If you look at the last two sentences, we do not agree, that was with the revenue submissions. Once a conforming interpretation given by this court and the judge's declaration is applied, the other ACT provisions simply apply in accordance with their ordinary meaning, precisely as Prudential submits in the present appeal. That's why I took you to what Prudential were submitting. Prudential weren't submitting that it should be treated as ACT, a payment of ACT. They were submitting it should be fed into the system, treated as a FII in the same way as a payment of ACT. So there is a modification to the provisions. And we find the same point being made in FII Code of Appeal 2, which my letter friend took you to, which is, I think, in bundle 2, it's tab 37. Maybe bundle 3 for you. Bundle 3, tab 37. And it begins on page 946. And if we just look at paragraph 90, because we find the reference to these later on in the judgment, the three possibilities canvassed before Mr. Justice Henderson as to the appropriate approach to determining the FNR in the case of mixer companies. So this is, I think, explained that mixer companies were very often companies which were at the water's edge, as it was called, and foreign dividends would be paid to that mixer company from a number of different sources at different rates of tax. And the idea was to mix high rates of tax with low rates of tax to produce an average rate of tax, which was somewhere in the middle. The problem, which I think perhaps my lord and my lady would appreciate, was that if you simply paid the high tax dividend directly to the UK and the low tax dividend, you would lose some of the credit in relation to the high tax dividend, because you could only get it up to the rate of UK tax. But if you mix the two, you would end up with a higher, better rate, which you could then apply on a dividend paid to the UK. So if you had 50% and 10%, and the UK rate was 25, you might lose a great deal of the 50%, and the 10% you would get, but that would only get 10% against 25. Whereas if you mix the two, you might end up with a rate of 30%, which you could then apply when you paid up a dividend from the mixer company. So the mixer companies were there to deal with what was perceived to be a problem from a taxpayer's point of view in the imputation system, which was that you only got credit up to the amount of the UK tax, as we discussed before. So that was the purpose of these mixer companies. And the argument here was, how do you deal with that in this new world of FNR? Do you apply the mixing rules to the FNR, or do you look at the dividends separately? And that's the three possibilities that are, well, the first possibility was you just look at the FNR of the Water's Edge company, but that was rejected. And then the second one is the FNR of the jurisdictions where the income has been subject to tax, applying where necessary a weighted average of those FNRs following the system of Section 801. So again, what they were proposing was not to say we're going to deem this to be foreign tax and apply Section 801 and the other provisions. what they're saying is that the FNRs would be mixed and averaged, applying the system in section 801 to the FNRs. And the alternative was the revenues, which was you simply looked at each source separately and traced it through to the UK. So that's the three possibilities. And then if you look later on at the passages that I think my learned friend took you to, where they approved what my lord has said at first instance, and it's paragraph 113. So the paragraph that they're endorsing is paragraph 54 of the first instance decision, where my lord said, as to the difference in approach which is reflected in the example which I have discussed, I consider the claimant's approach as set out in the alternative cases to be preferred. The alternative case is the second B, if you like. The question of the unlawfulness of the case 5 charge does not arise in a legislative vacuum. It has to be considered in the context of the actual tax system operated by the UK, which was binding as a matter of domestic law and had to be applied by the English courts, subject only to any disapplication and conforming interpretation construction, which may need to be needed in order to make it compliant with EU law. The introduction of tax or credit for tax at the FNR should therefore be implemented in a way which, as far as reasonably possible, reflects and goes with the grain of the existing UK tax lid scheme. It seems to me the claimant's approach, that's B, what we're talking about, respects this principle more closely than the revenues because it adapts and builds on the existing machinery for giving credit for the underlying tax. It's not an objection to this approach, in my judgment, the grant of relief from juridical double taxation of cross-border dividends, of which the Section 801 machinery forms part, is not itself required by EU law. The point is rather that the machinery formed an integral part of the UK's existing system for dividends, which made compliant with EU law. So what my lord was saying was that you adapt and build on the machinery, apply it to the FNR, not as I think my learned friend was suggesting, that you have to treat, under this approach, you have to treat the amount of the FNR as being tax paid in the foreign jurisdiction. That's not necessary. You simply apply the approach and machinery of Section 801 to the credits at the FNR, which put simply means that you apply a weighted average of the dividends that are received. So if there's 200 at 40 and 100 at 30, then you have to weight it to find the average. So in my submission, there's nothing in any of this which supports a contention that there is to be treated as being tax paid in a foreign jurisdiction. And I think that's probably all the authorities I need to look at. My learned friend took you to Class 8. We simply say, as you've seen from our skeleton, that we support what the Chancellor said in relation to the issues as far as they're relevant to this appeal. But of course, they're not in any sense binding on this court. So there were probably more significance in the courts below, where although they were not binding on the Upper Tribunal, it certainly was something that they would follow unless they thought it was wrong. And my other friend's also taking you to Jazztel, but as far as I understand it, there's no dispute about what's said in Jazztel about hidden retrospectivity. My learned friend distinguishes a situation where the taxpayer didn't know about, had no clue about European law and simply missed a time limit. Well, that's just hard luck. From a situation where they had some knowledge of European law, although how much it has to be, I don't know, and they made some effort to assert their rights in some way, He says that's a different situation. That's the situation we have in this case, and something different has to happen. And I'll come back to that, but it's a bit unclear as to what exactly it's supposed to be. So can I then, before I deal with it?
Sorry, you're going to tell us what your position was in relation to Jazztel, and I didn't quite understand.
Sorry, my position on Jazztel was that the only relevant part of Jazztel, I think, was where they overturned the decision of Mr. Justice Marcus Smith about hidden retrospectivity, where he was saying if somebody didn't know about their rights to European law, then somehow the time limits had to be extended to allow them to make a claim. And the Court of Appeal said that was wrong, as had the Chancellor in Class 8. We had asked the Chancellor in Class 8 to not to follow Mr. Justice Marcus Smith on that, and he'd agreed with that. He said that was wrong. But it doesn't appear to be an issue now because my learned friend accepts.
Well, it's
these
binding on
propositions.
this court in an event.
It's fine, yes, exactly. But
Is
it's
it,
clearly
was it part of the ratio of Jazztel? Because the actual decision on that issue was around section 320, where I think the Chancellor was not followed.
that's right.
That's one question I have.
Yes, there was another issue which was something like this.
So
Yeah.
do you have a position on whether it's ratio or
Well, I think I would say it was ratio because it's one of the arguments. I mean, if it's right, it would answer the question.
okay? That's one question. So
Allow
your
them to
position
claim.
is that it's ratio. The other question is in response to my lord, that as you explained, Mr. Bremner draws a distinction between no claim at all, no clue, and some idea makes some sort of claim. What is your position on that?
My position is there is no distinction between these. If a taxpayer has some idea about European law but does something which is ineffective, they're in no different position from someone who's done nothing.
Yeah.
There's no principle of EU law that says that if you do something which I think my learned friend put it reasonable, then you must be taken to have done the right thing. Essentially, it seems to be the argument. We say so long as there is no breach of equivalence or effectiveness, then it's simply a matter of the domestic legal system and a domestic construction of the domestic provisions and how it applies to the facts. In this case, how it applies to the letters and documents that were put in, objectively construed. That's the simple question. It's no different from any other domestic question. We say that European law has no part to play in this because there was an effective remedy, a number of effective remedies. There was no breach of equivalence. My learned friend didn't. I think he mentioned it in his skeleton, but he didn't develop that argument orally. We say that there's no breach of equivalence. The provisions apply equally domestically and to EU law claims. And there was no breach. There was nothing done by any emanation of the state, the UK, that could possibly result in a breach of legal certainty or any of these other principles. There's just nothing, I would say. Either the revenue of the UK or the courts. And I take my lord's point that if something that the revenue had done misled taxpayers, that there would be a domestic remedy probably in judicial review or something like that. That wouldn't be a European law point anyway. But all of this is academic because nothing did happen as a matter of fact, which could cause any complaint in my submission. The only problem that arose was because the European Court either changed its mind or developed its thinking between 2006 and 2012.
So what you're saying really, as a matter of principle, we mustn't lose sight of the importance of separating EU law on the one hand from the domestic machinery on the other. And it would be a danger to try and let the reasoning which has led to the court to adopt a conforming construction to have a kind of penumbral effect on domestic procedure as well.
Yes, that's exactly right, and that comes from the passage, the well-known, well-repeated passage that I showed you in Metal Gazelle Shaft,
Indeed.
which is that it's a matter for the domestic. The rules of procedure and for recovering tax are a matter for domestic law.
It can sometimes seem very tempting to say, in order to full practical effect of what the conforming construction has been held to be, in a situation where EU law, as we say, was not in a clear state and developed. It seems hard sometimes that taxpayers should be stuck if they get the procedure wrong as a matter of domestic law, just because they very recently didn't have a magic way of foreseeing exactly how the European Court was going to end up on the. But if so, that's just one of those situations where it's just hard luck and a fact of forensic life, which we should not be tempted into trying to ameliorate.
Yes.
In that sense, it could be said it's not any different to purely domestic scenarios where, as I observed to Mr. Bremner, a litigant makes a claim, it subsequently turns out when you get the decision of the Supreme Court, it wasn't the right claim, but you should have brought a different claim.
Yes. Well, and exactly, and there is an example of this, as my lady pointed out, and perhaps we could just briefly go to that. There's a recent decision of this court in AXA, which was all about, part of it was about the Salonen FII Supreme Court 3 type carry forward claims, and what that concern was the pleadings in a claim that had been brought in 2003 originally by AXA.
Where did we find that?
I think it's in the tab 50. Which maybe is in bundle 5. It's the very last tab of the domestic cases.
Yeah. So this is pretty hot off the press.
So it's a very recent decision, precisely. You might recognise some of the participants. There were a couple of issues about GLOs and the effect of. There was a lot of argument about my Lord's judgment in Prudential. The very last part of the judgment, which you probably don't remember at all, but as to what you were doing there and whether that has the effect that the claimants could recover under the old law rather than the new law of limitation. And there's a similar argument about whether they could recover under SEMPRA, even though it's been overruled by the Supreme Court in Prudential. So these were the two first issues. But then there was a separate issue about pleadings, because we now know, of course, that claimants can bring claims for carrying forward DTR credits in situations where there were management expenses covering it originally. When the claims were brought in 2003, and indeed up to 2009, before the ouster provision came in, it wasn't, Salonen hadn't been decided. And the claims were being brought broadly in terms of somehow claiming in relation to the year in which the management expenses were set and some kind of restitution. And I think this is something my Lord dealt with originally in the very first High Court hearing many years ago, back in 2008. There was all sorts of arguments, you may remember, about remedies as to whether they could recover in relation to management expenses and some form of restitution. And I think what your Lordship decided was, no, this would be a damages claim, because what they were essentially saying was, well, if we'd known about this, we wouldn't have set the management expenses against we would have done something else. We would have somehow rejigged our tax affairs so that we didn't use up the management expenses.
Yes,
There's claims along those lines.
Ringing a faint bell.
Yes,
very faint one.
Yes, and the problem that the claimants had was that they wanted it to be a restitutionary claim rather than a damages claim, because a damages claims require sufficiently serious breach, for one thing, but also had a 6-year time limit, whereas the restitutionary claims were potentially unlimited in time and didn't require sufficiently serious breach.
That's really what litigation was all about.
That was what a lot of the litigation was about, I think, exactly. So there was all that issue, but then by the time the appeal came from the Court of Appeal decision, which was in 2010, for various procedural reasons, it only came in about 2021. Salon had been decided, and so it was now known that, in fact, in a situation like that, where there are management expenses, you were able to carry forward, well, we now know the double tax credits. There was an issue as to whether it was the management expenses or the double tax credits in the Supreme Court. So the taxpayers were wanting to say, well, we in fact had this situation in the 1990s. There was a situation where the management expenses, we would have carried them forward and we could recover tax in the 1990s. They were also claiming that they could recover tax in 2017, 2018. That was rather an ambitious claim, on the basis that the pleadings covered causes of action that hadn't accrued yet. But there was also consideration of causes of action that had accrued, which were in the 1990s. And the question was, had they pleaded their case? Now, there's no doubt that they were asserting EU law rights. That was the whole point about the claim they were making. They were asserting their EU law rights. But this court decided, as a matter of construction of the pleadings, that they hadn't pleaded this cause of action in relation to the carry forward of DTR credits. Not surprisingly, because they probably wouldn't have appreciated it at the time. And the conclusion is on paragraph 164, which is on page 1567. I'm not interested in the details of why that was. The only point I'm making is that, as my lady said, that is an example of a case where they were asserting their rights from 2003. But the fact is that they have to do it correctly under domestic law.
Right, so you say that the rejection of the submission that Mr. Bremner made in that case, that quote, it cannot be right that a litigant has to predict the precise basis on which a domestic court may ultimately arrive at a conforming construction of the UK provisions, that resonates here, because you say in effect the submission advanced to us is much the same.
It is, yes, and it's based on the fact that they were trying to assert their EU law rights. So this isn't a case where they were completely ignorant. They were ignorant of this particular nuance of EU law, but they weren't ignorant of their EU law rights generally.
Yep.
So they're really in the same position as the claimants here, who were bringing their claims at a time when they didn't know about the FNR, obviously, because that hadn't been decided yet. But they were, in general, complaining about EU law breaches. I have to probably right to say that there is an application for permission to appeal to the Supreme Court in this case. So
that comes as no surprise.
Can I then sort of draw the threads together as to what my general submissions before moving to the particular issues? So first of all, I don't think this is an issue, but I want to make the basic point. The domestic courts have determined the conforming interpretation of the UK legislation in the Prudential case. It was decided by Mr. Justice Henderson, upheld by the Court of Appeal, and in my submission also upheld by the Supreme Court. I don't think they mentioned conforming interpretation, but the case was argued on the basis of whether it was you could get credit for tax paid or for the dual credit. So, and they said the dual credit. Secondly, this conforming interpretation is regarded as always having been the correct interpretation of the legislation. And that is a normal application of the declaratory theory of law. And it makes no difference that in the past, no one would have thought the law to be what it in fact was at the time. Thirdly, and again, I don't think this is an issue, there is no objection under EU law to having reasonable time limits fixed in advance. That is so even if the time limit has expired before the claimant could have known about the relevant EU law position. Fourthly, this may not be common ground, there's no principle of EU law that a claimant can be treated as making a claim which it did not in fact make on the grounds that it is done what is reasonable to assert its EU law rights. And the difficulty with such a proposition is it raises such a number of questions. What is meant by reasonable? Reasonable to whom? The court would have to make a decision if that was a principle as to whether they'd acted reasonably, presumably in the light of all the advice they were given, in the light of their circumstances. That's not part of EU law. EU law simply requires an effective remedy. How the taxpayers exercise that remedy is a matter for them. Fifthly, it's said to be significant a number of times by my other friend that the taxpayers made the claim which was available under domestic law, rather than a claim for DTR which was not, he says, not permitted on the face of domestic law. But in fact, the treatment which the taxpayers sought was itself not available under domestic law. The taxpayers sought to return the dividends as exempt. But domestic law is quite clear. It's only dividends from UK resident companies which are exempt under Section 208. So what the taxpayers did in this case was no more available in my submission under domestic law than claiming a DTR credit. Both of those relied on EU law providing a conforming interpretation or a disapplication. So in my submission, there's no distinction between the two. Sixthly, the evidence of all the witnesses for the test claimants was, first of all, that they were aware of the option of a restitution claim or a statutory claim, and that they decided what to do based on professional advice in the light of their own circumstances. That's not to say in every case they followed the professional advice, and they may have taken their own decision, but they based it on the advice. And secondly, that the revenue did not at any point contend or argue or put forward the proposition that the dividend should be exempt. The seventh point, the claim for DTR credit for underlying tax could have been made at any time based on EU law. It's not a breach of the principle of effectiveness that such a claim was difficult or even impossible to conceive of due to EU law not having been clarified. Principle of effectiveness is looking at the domestic system and whether it provides effective remedies, not whether EU law is sufficiently clear. And just to add to that, on top of that, English law also provided a common law claim in unjust enrichment, which I think it's fair to say is probably more flexible in some ways than the statutory claims. And eighthly, equally, there's no principle of either EU law or English domestic law that a taxpayer is not obliged to make the correct claim or take the correct proceedings until a conforming interpretation is made by the domestic court. Ninthly, the European law elements of this case can be determined by applying the principles which I showed you in paragraph 85 of Mettelgesellschaft. That's the oft repeated paragraph. And tenthly, there were no difficulties or uncertainty caused by either the revenue or the domestic courts. Any difficulties or uncertainty were a result of the way that the decisions of the Court of Justice fell out. And that is, I would submit, obviously not something for which the member state is responsible. And finally, 11, there is no breach of the principle of equivalence. The remedies that are available in domestic law are all available to deal with EU law claims in just the same way. Now, and my learned friend accepts, this is not one of the numbered submissions, I'm just going to come on to commenting on the sort of broad case that's put against us. He accepts that if a taxpayer has done nothing, then it cannot complain about the time limit running out before it could have known of its claim. He says it's different if a taxpayer has drawn the wrong conclusions about EU law and taken the wrong course of action for its own reasons. And the difficulty, then there was the difficulty is where does that lead? It seems to be that the taxpayer must be treated, or what he did must be treated as being the correct course of action. But the question one might ask rhetorically is why should such a taxpayer be in a better position? The complaint that such a taxpayer is making is really the same. That before it discovered what it ought to have done, the time limits had expired. We're assuming that to be the case because otherwise they would have presumably brought claims. It is, we would submit on analysis, really the same complaint.
It's unfair because I didn't know then what I know now.
What I know now, yes. And by the time I knew precisely what the position was, the time limits had expired. Now, it isn't, this is maybe a jury point I might make, but it's perfectly possible for taxpayers to make claims before the courts have decided things, anticipating what what might happen.
Well, that's the normal way the law develops.
And
It's the basis of the development of the law of mistake as well.
well, we're going to have anyone who has the misfortune to be sitting in May on the appeal in FII. There's going to be a lot of discussion about that kind of point in relation to Section 32(1)(c).
But it's the same fundamental point.
It is quite fundamental, yes, but it is correct, and it's also true that the way the law develops can be quite a matter of happenstance. The way decisions happen and the way that appeals go to the appeal to the Supreme Court in FII, which resulted in an overruling of DMG, might never have happened if there hadn't been an appeal to the Court of Appeal by the taxpayers from Your Lordship's judgment about limitation, because there would have been nothing to take to the. So that happened at that point. I mean, many times the way litigation develops is quite a matter of happenstance. Who wants to litigate? Who's in a position to it? Who has an idea at the time? But anyway.
Not to mention which judges hear the case.
Which judges hear the case? Yes, exactly. Exactly. But the problem with, well, two problems. One is there is no principle of EU law which supports what my learned friend says. There's no case which says, well, if you don't know what EU law is, but you've made a stab at it, then you must be treated as having made the correct claim or taken the correct procedure. Can I then just say something before I get into the issues about generally what a claim is? Because it's quite important in some of the issues. What is a claim? In my submission is a practical question.
Well, hold on. This seems to be a very general question. I mean, surely it's entirely dependent on context.
It is, exactly. Well, that's what I was going to come on to say. It depends on the context, because the purpose of a claim, the fundamental purpose, is to make in this case the revenue aware of what you say you're asserting a right to. So you're claiming a double tax credit, you're claiming capital allowances, and claiming all sorts of different claims. And so you're right. If whether a claim is a claim for one thing or two things depends on the context. But the important point in my submission is if you're claiming one thing requires you to establish certain points, and claiming something else requires you to establish other points, those in my submission would be treated as separate claims.
Well, they may or they may not. It depends on the context, surely.
Well, it depends on the statutory provision.
Exactly.
If it makes a point about what claims are, yes, it can.
And a claim is a technical term in tax law, isn't it? I mean, in procedural code.
It is, but it's not defined anywhere.
Well, that is.
That's.
There's quite a lot of learning on what is necessary to constitute a claim, where the legislation says something can only be done by making a claim. So it's a claim for double taxation relief.
Yes.
And yes, the answer very often is you don't find much, if any, detail about what needs to be done. And then you fall back on general principles of the type you were mentioning about conveying the minimum information necessary to the revenue and so on. But equally, the revenue may be very prescriptive and say such and such material has to be included in the claim, and then that's all spelled out in
Yes.
exhaustive length.
But I think my point is if there are, well, we're going to come on to look at this in the context of withholding tax and underlying tax, but if there are two items like that you are claiming, to say that's a single claim is not, I would suggest.
I don't understand how one can pose such questions at such a high level of generality, because the question must always be what is required by way of claim in the particular context.
That is one, but that's not the question I think we're looking at. Well, no one's no one's saying that arguing about what the requirements of the claim are. What is being argued is as a matter of, as I understand my learned friend in some of the issues, is saying, well, all of these are one claim as a matter of legal analysis, although you're asking for a number of different things. They're all to be determined as one claim.
Let me give an obvious analogy, which is so obvious that barely needs saying. If you have a claim for damages, and you also have a potential claim for restitution, depending on your level of generality, you can say that those are the same or they're different. They are legally different, and therefore you could say they're two different claims. But at a higher level of generality, they're both claims for money. Give me money. And in that sense, they're the same claim. So it all depends on the level of generality and the specific context.
Yes, but the issue we've got here is, have you made a claim for a certain thing, although you didn't specify it? That's the kind of issue we're dealing with.
Well, indeed so, but that must depend on the context, which is what were you required to do, and what did you actually do?
Yes, but just to looking at your lordship's example, if you issue a claim form with a claim for damages, and you don't mention restitution, then no one would say you're making a claim for restitution.
But that's in the context of the applicable
the
procedural code.
Yes, exactly.
And the applicable law.
Because it's not there. You haven't made a claim in the pleadings, yeah. Anyway, can I just state what our position is generally, and we'll come back to it when we're looking at the things. What we say is, as regards these claims, that there are separate claims. First of all, for each dividend, and secondly, separate claims for withholding tax and for underlying tax. We'll come back to that. But that's our position in relation to the claims, that they're all regarded as separate claims, and they're dealt with obviously separately. Because each of these, you have to look at the particular circumstances, the tax paid and the particular dividend, etc. So that's what we say about that.
Presumably you say that reflects the fact that available credit is calculated on a dividend by dividend.
Exactly. Yes, of course. Yeah. It has to be, because you have to know what the tax is. You have to know what the tax rates are in relation to that dividend, etc. And the withholding tax is obviously a separate tax.
Yes.
At a different rate.
Available, very significantly, the available credit is determined on a dividend by dividend basis because of the basic rule that you can't, ignoring youth and so on, you can't offset credits arising on one dividend against
another dividend.
Yes.
Yes, exactly. Yeah, that's the imputation system. You're relieving double taxation in relation to each dividend.
So you can't, for example, ever lump your dividends together on a return for that purpose, because you would be mixing your credit.
But even if you do, you don't change the nature of the claims.
Yes, but what I'm trying to
get
at is, I think it is all about context, and part of that is understanding the system.
Yes, but understanding the imputation system and understanding the fact that there are different. Yeah. Each dividend can be different. Of course, they might not be. You might find there are two dividends that happenstance are the same, but that's just happenstance. Yeah. Can I then start then with issue 2, which is in relation to the Para 51 claim? And I'll take you to Para 51, which is in tab 11. it's the opening words it's the words in subparagraph 1 which are important. A company which believes it has paid tax under an assessment which was excessive by reason of some mistake in a return may make a claim for relief. And it's so the overpayment of tax, the excessive payment under the assessment, has to be by reason of a mistake in a return. And we say that that doesn't allow you to that isn't a wide claim in mistake, as perhaps the new provisions in tab 12 are more. It doesn't allow you to say, well, I made a mistake generally, and therefore I overpaid. There was an overpaid tax and assessment. The mistake has to be in the return, and the significance of that, we would say, is that there has to be something in the return. So, not putting something in the return, as such as a claim, in my submission is not a mistake in a return.
So
It
do
may be a
you say
mistake.
that
You may have
any,
made a mistake, but it's not a mistake in a return.
any omission is not a mistake? Is that effectively what you're saying? If I
Omit.
omit something from a return, it's not a mistake. Is that
Well,
what you're saying?
I'm saying two things actually. One is, without the claim, there is no mistake in the return. The return is correct.
I think I understand that, and just to make sure I've understood it,
And
the way you're putting that is to say dividends are correctly returned as fully taxable. Look at the return, there's no mistake.
yes,
And for so long as you haven't claimed double tax relief,
the return is correct.
follows that the return is correct.
Yes.
Okay, thank you. So that's one way you put it.
But you can't go further, which I think is my other friend goes and says, well, the return isn't correct because we made a mistake by not making the claim.
Okay, but you said you had two ways of putting it.
Well,
One is that there's no mistake at all because you haven't made a claim yet.
yes. Well, the other way is really an answer to what my other friend says, which is it goes further, that you can look not at just what's in the return, but you can look at the fact they made a mistake by not making a claim.
And what's your answer?
And we say that that's not, there's not a mistake in a return. If your mistake was not making a claim, and
Sorry, I can't at the moment see how that's really a separate answer to your first point, because, you know, just ignoring 51(3)(b) for the moment, which I think you haven't taken us to 51(3)(b).
yeah,
Tell me why it isn't a normal use of language to say I made a mistake by failing to tick the box that said I wanted to claim DTR.
well, because you may have made a mistake. I agree, you have made a mistake, but that's not what Section 50, Para 51 is about. It's about a mistake in a return,
Yes, but
rather than someone making a mistake,
sorry,
which has resulted in them not paying.
that's why I asked whether you're really relying on any omission from a return not being a mistake.
Well,
I really am. I can understand your first argument. I haven't made a claim and therefore the return's perfectly accurate. But I'm struggling with your second at the moment to understand it, if it is a second argument.
It isn't. My argument is the first argument, but
Okay.
I'm responding then to what's being said is, well, no.
Okay, so it really is an aspect of your first argument.
Yes, it is. Yes,
Thank
sorry.
you.
It is. Yes. It's being said, no, we did make a mistake. We didn't make a claim. And we say, and I say that doesn't result in there being a mistake in a return.
You could say that's a rather narrow approach. I mean, you're just, on a sensible, if you asked the sensible man in the street whether they've made a mistake when they fail to claim.
But you wouldn't be
for the
asking them the
tax-
statutory question if you asked them that.
Well,
If you asked them that, then no doubt they would
no,
say,
so let me finish. If
Yeah.
you ask them whether they made a mistake in the return when they failed to tick a box, wouldn't most people think that was a mistake just as much as putting the wrong number in for something?
well, no, because when you put the wrong number in, there is a mistake. You can see that, that's a mistake. The two things are different. Can I just make this submission, which is, we say that one of the policy behind this is that claims in elections should be dealt with under their own provisions and not under para 51.
Well, I can
And we say that, and that's dealt, and the way that is dealt with is by what I've just said, that you not making a claim is not a mistake in a return. If you did make a claim in the return, that's where 3B comes in.
can
And,
I
and that has
just
to be dealt with because there is a mistake in the return,
right?
and that's taken out specifically.
Sorry, can we take this stage by stage? When you said there's a separate code for claims, can we go to paragraph 56, please?
Yeah.
Do I find that?
Yeah. It's page 171.
Thank you.
That
That's allowing claim, that's a part of the regime
that-
for claims.
That fits with your submission insofar as it appears to provide for a separate code where you've made a mistake in a claim.
Yeah.
But it only applies where you have made a claim in the first place.
Well, you can't have made a mistake in a claim if you haven't made a claim.
Yes, but my point is that you are saying there's a separate code for claims, but I'm saying if your approach is right, there's a disconnect between 51 and 56. If your mistake is failing to make a claim,
Well, then your remedy is to,
covered by 56.
no, it's not.
Well,
Your remedy is to make the
56 says by including it in a return or otherwise, which might be
No.
thought to cover
Yes, you can
not
make-
including it in a
You can make
return.
claims outside returns.
No, but okay, my point is a slightly different one. It assumes that you have made a claim
Exactly.
and only deals with mistakes in that claim.
Yes, but if you haven't made a claim, you don't need this provision. In fact, you couldn't apply it. What you need to do is make the claim.
Okay.
I mean, it's
Yeah.
quite straightforward. You have to make a claim. If you've made a claim, then there's a mistake in the claim, then you can correct it.
So
Under this
can I
provision.
just see if I've understood the point you're making, and not necessarily by reference to this case. So if you're a taxpayer and you might be able to claim a relief against tax,
Yeah.
and you don't claim that relief, and subsequently you think to yourself, that was unwise of me, I should have claimed that relief. You say that's not a mistake within paragraph 51, because there's no mistake in the return that you made. It's that
You didn't make the claim.
you didn't make the claim that subsequently you think you should have made.
And then you
And you say the remedy to that is to then make the claim.
Exactly, yeah. Under the claim procedure, and there are rules about that, time limits, and there are all sorts of different claims in the Taxes Act that have to be made with different regimes.
Then
And the problem, the
Because if
point is,
on your
para 51
argument,
shouldn't
if
fail
any
to-
failure to claim something that you might be entitled to is a mistake in a return, then this is always going to apply.
Exactly, and it will override the claims procedures, specific claim procedures.
okay, so going back to, if I may, to 51
Yeah.
and 51(3)(b,
Yeah,
in a sense, so if you say that ties 51(3)(b) ties in presumably with 56, because it disapplies 51 where you should be thinking about 56. You've made a mistake in a claim.
Exactly.
But you don't, I think your submission is that unlike the revised para 51, which does explicitly provide for failures to make claims, you didn't need
Exactly.
to
Yes.
make that provision in the original 51 for the reason that you gave earlier,
Yes.
which is that your mistake, your claim, your return is correct. You just haven't made a claim.
Exactly. Exactly. And that's why, and 3 is necessary, 3B is necessary because there would be a mistake in the return because it's assuming the claim is in the return or the election. And so you have to take that out in accordance with the policy of dealing with claims by the claims mechanisms. You have to remember that there are claims, I mean, for instance, group relief claims, inordinately complicated provisions. It would be quite difficult if para 51 barged into that whole
Yeah,
procedure.
and they've got their own time limits.
In their
I
own
mean,
time
one of the
limits.
things that's quite difficult to sort of see here is, in one sense, the relevance, because broadly the time limits for DTR claims and para 51 claims were the same. But if you compare it with something like group relief, where it was a much shorter time period,
Yes.
the time periods make a big difference, don't they?
Yes. And they can be much longer, group relief as well. They can extend to,
Yes,
For
so
the
the
inquiry.
initial time limit is much shorter.
yes, yeah. But there are all sorts of other claims which have different time limits. And elections, of course, as well.
Right, now,
So
so what it comes down to, as you've made clear, is construction of the words mistake in a return. Now, again, do we not have learning on this? I mean, this can't be a new issue as to what is meant by mistake in a return.
I don't think there is. I mean, I don't think anyone has questioned it up until now, because if you have a claim, you make a claim. I mean, it's just. I'm not aware of any cases where someone's tried to bring a para 51 claim where they should have made a claim. But
Well, there have been cases which look at the question whether a claim was in fact made. I mean, I think of cases like Gallic leasing, which in the 1990s,
yes,
I remember being involved in it a very long time ago. And that was, I think, a claim for group relief. And anyway, maybe I got a particular type of claim
Yes.
wrong, but there was a certain amount of discussion.
Gallic
about
leasing.
Yes.
yes,
About what effectively what it was you had to do in order in a case where the revenue had not specified a
Yes.
particular form.
that's right. Yes, exactly.
Although the TMA, as it then did, probably still does, enables revenue to specify a specific form of claim
If they
they
want.
want to. They
Yes.
hadn't done so. And so I think the general thrust of the decision was one should adopt a fairly, I won't say relaxed, but a fairly generous approach to reasonable steps which were taken to convey the relevant information to the revenue.
Exactly, but it's all about conveying the information, right, that you are wanting to make, because you have to do something. The whole
That's
point
the
of it is you've got to
situation.
make a claim. You've got to do something.
So that's in a situation where the particular relief sought, it may have been group relief, whatever it was, explicitly had to be made by way of a claim.
Yes.
That's very common. I mean, throughout the tax code, you find this such and such a relief may only be made by a claim. That's why it's a bit surprising, as you noted the other day, not to have a provision to that effect in relation to DTR, except rather obliquely.
Yes. Well, there was. Maybe I'm not sure. Maybe under the rewrite, it may have
It's clearer
changed.
under the re-
Sorry,
It is a bit clearer.
under the yes, yeah.
Yes, I'm
But-
sorry, I'm
but-
talking about the historic.
Am I right in understanding that it's your submission that it must be implicit that you must make a claim? Because how can HMRC accord DTR without somebody claiming it and providing the requisite information?
Well, yes, but also there is, I think it was subsection 6,
Yeah.
which assumes there's a claim, and
As I understand it,
I don't think there's any dispute.
My understanding is there's no dispute that you do require a claim.
Yes.
It's implicit in what's whatever it is, subparagraph 6.
Yeah.
But also in section 806, which gives time limits for the claim. So, but also common sense. My lord, I agree.
Yeah.
A point my learned friend made, which he seemed to think was a point in his favour, is that in general there are very few formalities for claims under the UK Tax Act. It's not like, I think one of the cases that my learned friend referred to was Milica, the German case, where you had to provide a certificate in enormous detail from the company paying the dividend in order to get your credit, and the German tax authorities were attempting to apply this incredibly difficult requirement to a foreign company I think it was said that probably would have made it impossible because they had to provide all sorts of information which really only a German company could provide. So there are very few requirements generally. Although in group relief, I remember in the Marks and Spencer's case, we had to deal with, there are a few requirements which are actually impossible for a foreign company to comply with. I mean, one was, I think you had to provide the name of your tax inspector in making the claim, which has obvious reason within the UK why you would do that, but it's not possible for a foreign company. But these provisions were all, as far as they were disapplied in Marks and Spencer's to allow them to make the claim. But there are very few requirements, formal requirements. There's no requirement that you should, for instance, have to specify the statutory, the statutory provision, and the number under which you're making the claim. As long as you make it clear what claim you're making, then you can make it in a number of different ways. So we don't have the problem that maybe some other member states had of very prescriptive formal rules about making claims. Can we then look at the claim itself for completeness, which is it's in a joint supplementary bundle at tab 3. Sorry. And in my submission, this is a very appropriate claim if the position was that the income was exempt. And in paragraph 3 in particular, they specify the mistake relates to the erroneous inclusion within the taxable profits computation of overseas dividend receipts shown in the final return as scheduled in case 5 income. The correct application of 208 provides that all overseas sourced dividends should not be chargeable to UK corporation tax. And then they are identified. And what this isn't on any view is a claim for double tax relief in my submission. And it's impossible under any orthodox rules of construction, domestic rules of construction, to construe this as a claim for double tax relief.
You say it makes no difference that the claim they sort of meant to make or would have made if they'd known about it was a claim for relief at the foreign nominal rate, which is in many ways similar in its economic effect to the exemption in section 208, but is juridically a very different sort of animal.
It is, and it makes no difference in my submission that in the particular case, it would have produced the same result. It cannot be a principle that you must be taken to have done something else if it would have resulted in the same consequence.
And the argument seems to be section 208 should be read as a matter under principles of EU law as effectively providing exemption.
Exemption, yes. And that was the many taxpayers
Very
took
understandably.
that position.
Yes, it was their position, but it turned out.
Well, understandably, perhaps as a matter of law, but also as a matter of practicality, because at that stage, the only alternative probably would have been credit for tax actually paid underlying, because that was the FNR. Nobody had thought of the FNR in 2009.
And that brings us back to the practical impossibility for any ordinary taxpayer of finding out what the underlying tax actually paid was in respect of portfolio dividends.
Yes, exactly. And it may have been thought at this point that European law might say, well, that is a breach of effectiveness, and therefore we ought to exempt the dividends. That was before Haribo was decided and the other cases, which it was following, in fact, in Milica. So, as your lordship decided in Prudential, that is not a matter that the member state is answerable for. The fact that they can't get information.
But as I understand your argument, what you say is that it would have been open to the taxpayer to say, firstly, UK law is non-compliant with EU law, and secondly, the way in which it should be made compliant is by giving us a credit at the FNR. They could have made that argument, you say.
Or
the fact that history shows that taxpayers didn't make that argument and it was an invention of the Court of Justice is neither here nor there on your case, if I've understood it correctly.
Yes.
Because the argument was open to be made.
The argument was made, and equally, they could have made a claim for underlying tax actually paid, which some taxpayers did. One element of the dual credit, I think, as your lordship decided.
Yes.
Or they could have made a claim in restitution. Which many taxpayers did, we do know.
Well, that's the
From
account of
2003, they were
what
making
one means by the word claim here. They could have made a high court
high court claim, yes,
Yes.
sorry.
On the other
Sorry.
hand, we're talking here about claims in the technical sense. I mean, under paragraph
Yes.
1, that's not looking at
No,
litigation.
my point was a wider one on
Yeah, oh, yes.
effective remedy. They could have made it, alternatively, they could have made a claim. So all of these things were available to them. And that, in my submission, is the extent to which member states are required to provide an effective remedy. They were to provide the remedy.
Yes, because the case against you is put both under EU law and domestic. So you've explained why you say EU law doesn't require us to construe this, as it were, as something you say it's not. And under domestic law, I don't think we've been taken to the case that was referred to earlier by my lord about meaning of, what claims need to do and so on. But you say just your position, as I understand it, is reading this, can't possibly be a claim for
The DTR, yes, at any, either underlying
You
tax.
don't need to rely on any authority.
Well, you
Well,
just need to
You say ordinary principles of construction of documents,
Exactly.
which are well established.
yes, exactly. Now the other point is section 114, and Ms. Bograno is going to deal with section 114, but we thought it would probably be sensible to deal with it after I've dealt with issue 5, because we understand that it is brought in under issue 5 as well, so Ms. Bograno can then deal with.
Whenever convenient.
So I will therefore, I'll come back to that when we deal with issue 5. Unless there's anything further on issue 2, can I turn to issue 3? that is one of our two appeals from the Upper Tribunal. And the question here is, was there a claim for underlying tax? And can I think what we have to do is look at the return in question, which is alleged to have made the claim. And it's in the joint supplementary bundle at tab 11. So this is the return for Schroeder. And it's page 78. Box 61 is about, it's just at the hole punch, right? If you have a hole punch, about 2/3 of the way down. Double taxation relief. It says exclude any amount included in box 67. That's not relevant. But then it says put an X in box 61A if box 61 includes an underlying rate relief claim. And there isn't any, because the only claims that are being made here are in relation to withholding tax. And we can see that if we look at the schedule, Schedule C, which is on page 82.
All right, this is a very relevant question, but could you enlighten me as to why the numbering of the boxes is non-sequential? It leaps from 60 to 148 to 162, then goes back to 61, and then it goes to 153.
Yes.
Seems to be designed to confuse.
I might ask about that.
Well, I mean, this is a historic form. I mean, this is donkey's years ago now,
Yes.
but nevertheless,
sure
it seems
there
very
was
strange.
I suspect it's the way the form developed.
Yes, yes. But anyway,
So page 82.
it's page 82, which sets out, breaks down the figure that was in the box. And you can see that it has the country of origin of the dividends, the gross dividend, the treaty rate. The treaty rate is, just have to explain this, treaties will often have a provision which limits or provides what the maximum amount of withholding tax can be charged by the parties to the treaty. And when you're claiming withholding tax credit under the treaty, you can only claim the withholding tax to the extent permitted by the treaty, or some such words. So you can't claim more than is allowed under the treaty, even if the state itself, in breach of the treaty in some sense, charges more withholding tax. So I think that's why you have the treaty rate there, which is the maximum amount that can be claimed. And then tax deducted, nothing. Withholding tax suffered, and you'll see that adds up to 2040. And what you don't find in any of this is any column in relation to underlying tax, because there wasn't any being claimed. You can see there's a few cases of excess of treaty rate in the second last column, where they must have been charging a bit more than is permitted under the treaty. So the withholding tax suffered was 2,422. The available for relief was 2,023.
And I'm sure most people find this entirely obvious, but just to check I've understood what you said earlier, we see two entries for each of Ireland, Japan and Netherlands, as against a single entry for, say, Spain and Switzerland. And do I understand that's because as you said earlier, it's dividend by dividend. So we understand that there's two dividends in, say, Ireland, but only one dividend in, say, Spain.
Yes, I think that's right.
It's also worth noting, which may be relevant to issue 3, that some of the dividends didn't have withholding tax.
Yes. So they've listed all the dividends, all these dividends, but some they're not making any claim in respect of.
The reason I make that point is, as I understand it, issue 3 is, well, we've claimed in respect to withholding tax, so it should extend to underlying tax.
They should be treated.
That would seem to be relevant, even if it were right, it would only be relevant to where there was a claim
For withholding tax.
for withholding tax in respect of a particular dividend, and therefore might suggest it turns, if right, issue 3 turns on the happenstance of whether there was withholding tax on that dividend. If that's,
I think it would have to, unless they're arguing that there is one claim for withholding tax for the whole lot, which in my submission would be wrong.
Well, then though you need to go back to the legislation and ask yourself whether the claim is a single claim for all dividends, or whether it's a claim on a dividend by dividend basis.
Yes. Well, we can look at the legislation, but the principle of the imputation system, which the legislation is giving effect to, is that you have to look at each dividend separately, because you have to determine whether there's what double taxation is of that dividend.
Yes.
You can't look at all the dividends together, or
And as I said earlier, you only get credit up to the amount of the tax,
on that dividend.
Correct.
Yes. So you can't even lump together two dividends from Ireland. Otherwise, you
But
produce.
for present purposes, it's potentially relevant to the argument that some of these dividends didn't carry withholding.
Yes. I don't know what their position is on those, and whether they say they come within the principle. We'll find out.
Responded to.
Yeah. You'll also notice that in relation to Japan, the two dividends actually have a different treaty rate, interestingly, as well as everything else. So you can't necessarily assume that a dividend from the same country will have the same rate.
So I'm going to say nothing may tell on this. I can't read what is above the headings to the column after withholding tax suffered. Is the next column, it says expensed WHT, or is it a cross-heading reading? And then the word hasn't come out clearly in my print of this.
Yes.
Maybe nothing at all turns on this. I'm just trying to see what the.
I think that column is expense WHT.
Should it be expensed WHT as one column? And then what's the heading to the next column then?
Well, it says excess of treaty rate.
But
You might expect there to be something before that.
Before that, exactly. That's what I'm puzzled.
Yes,
I expect it to be tax in excess of.
tax in excess.
I was not in. It was the word in bit, was it? But in which case you.
Or it could be WHT in excess of.
Well, anyway,
Yeah.
But that penultimate column illustrates the point we made earlier, that you can only get relief
Exactly. Yes.
at the treaty rate. So they've, in the case of
yes.
Ireland, where the treaty rate is 0, they've had to take out the 201.
Yes. For some reason, there was a withholding tax in Ireland on it, and similarly with Netherlands, although only for one of the dividends. But the same point about different rates could apply with the underlying tax, because we know that in certain member states there were different rates for companies in different parts of the country, and indeed we possibly have the same, at least potential position in the UK, with Scotland having perhaps different corporation tax rates than they could have in the rest of the country. But that was the case in, for instance, Ireland, where there was the Dublin docks, I think, which had a lower rate of tax for people who were there rather than the rest of the country. So you can't lump together, even within the same country, dividends for the reasons we've said. So when our submission on this is that there are separate claims. The question is not whether, for this purpose, whether there are separate claims for each dividend, although we say there are, the question really is, in respect of each dividend, is there a separate claim for withholding tax from the claim for underlying tax? And I understand the case to be you only make one claim for double tax relief, and that encompasses withholding tax and underlying tax. And the fact that you haven't claimed any underlying tax doesn't make any difference. You still somehow, which I'm not quite clear on, made a claim which encompasses underlying tax.
I think the argument against you, as I understand it, is that the legislation doesn't tell you that you have to make it. The legislation isn't prescriptive.
That's true.
As I understand your answer to that, is simply look at what was actually done.
Well, two things. One, look at what the legislation is implementing. It's implementing an imputation system where there are quite separate rights to withholding tax credit and a right to credit for underlying tax. And they're separate, and they've got different requirements, different elements to them. And those we would say are separate. There's nothing to, they're separate claims, and to deal with them otherwise would be artificial to say that they're all one claim, but you would look at part of the claim to decide whether they're entitled to
So you rely
tax.
there on the fact that there's different provisions in the legislation.
Yes,
They're obviously juridically different.
they're all giving double tax relief in the broad sense, but that doesn't follow from that they're all one claim. And indeed, it proves too much in some ways, because it would mean all your claims for double tax relief would be a single claim, if that were the analysis. It simply can't be the case. So if we just look at section 790, I think that's what my last time was relying on.
So you just to make sure I've got it, you're taking us at the moment to one argument which is based on the legislation, but presumably you're also, because you've taken us to the return, you're relying on more forensic factual point.
They didn't make a claim.
They actually didn't make a claim.
Yes. Well, I suppose I've got to deal first with the argument that you only make one claim for double tax relief.
Yes.
If that's the case, well,
At this stage,
and
I'm just trying to understand how.
but assuming that's not the case, then there's no way that you could construe these documents as being a claim we would submit for underlying tax relief. Indeed, by not putting the X in the box, they have denied expressly that they're making a claim for double tax underlying tax relief. And for what it's worth, the wording of the box suggests that that's a claim, not part of a claim. The double tax relief for underlying tax is a separate claim.
It does use the word claim, yes. It does use the word
But
claim.
as you claim, it doesn't say if part of the claim is for underlying tax. No.
No, it says
You may say that the
if
that
it
kind of word.
includes, quote, an underlying rate relief claim.
Claim, yes. But I think my learned friend would say that really should say it includes a claim, a part of a claim for DTR, which is in respect of underlying tax.
You're going to take us to the legislation.
Yes. Section 790. It could be said, and a point I think my lady made, in fact, what we should be looking at here more accurately are the double tax treaties. Because actually the claims that are made are not under section 790. They were under the relevant double tax treaties. So,
And 788, which is
and 788, which gives effect to them.
domesticates them in UK law.
Yes. Well, they're all then enacted as a schedule to a order in council, I think, which brings them into UK law, which is under 788. And maybe something we ought to just provide so you've seen it, or so that some of the court have seen it, how the double tax treaties are structured, but they're structured in a similar way. There are two separate parts to the double tax treaty, one which deals with tax on the dividend, which is the withholding tax, and one which deals with specifically underlying tax. And the form is not dissimilar from Section 790, because Section 790 is intended to be, well, it is, the way it works technically is by deeming this to be an arrangement. So it's in the kind of form of the arrangements. So what you can see is that there is credit under subsection 4. Tax paid under the law of the territory outside the UK and computed by reference to income arising or any chargeable gain accruing in that territory. That's shall be levied against any United Kingdom income tax or corporation tax computed by reference to that income or gain. But as my learned friend said, that doesn't apply. Credit is not allowed by subsection 4 if in under little 2 the dividend is paid to a company within subsection 6. And that is a case where not less than 10% of the voting power is held, so that's non-portfolio dividends. And then over the bottom, the company receiving the dividend shows the conditions specified in subsection 4 are satisfied. Any tax in respect of its profits paid under the law of the territory by the company paying the dividend shall be taken into account in considering whether and to what extent credit is to be allowed in respect of the dividend. So it is again a separate credit. I would submit from the credit any credit that's been given in relation to withholding tax. And then there are provisions which extend that to companies further down the chain. So it doesn't only apply to the company paying the dividend. If there's tax being paid 5 or 6 companies down, then you can claim for that. But there's nothing we would submit. There's nothing in this this provision, or indeed in the double tax treaties, which we'll show you, which indicates in any way that there is a single claim for double tax relief. My learned friend pointed to subsection 1. All that says is that you get relief from income tax and corporation tax in respect of tax payable under the law of any territory outside the UK by allowing that tax as a credit, notwithstanding there is not for the time being any arrangements under 788. And that is unilateral relief. But the fact that it's unilateral relief doesn't tell you that there is only one claim. As I said, the argument's rather odd because what we are in fact dealing with it would be, in this case, claims under the double tax treaties. So,
but that seems to involve the proposition that 790 isn't applicable. Because, as you say, that's for unilateral relief, not under the treaties.
It wasn't applicable in relation to the...
Sorry, but if that's right, why are we looking at section 790 at all?
Well, I'm looking at it because my little friend took you to it. I think that's probably the answer.
All right, but can I be clear? Your submission is that section 790 is irrelevant because the claims are made under the treaties. They're not claims for unilateral relief. That's your submission. That's what
the claims that were made at the time are not claims. Were not claims for unilateral relief. As far as we can see, I mean, it looks because they all include a treaty rate. One assumes that they were all under treaties, and they all look like countries that would have treaties with the UK. So they're all under the treaty, and they're all claims for withholding tax under the treaties.
Yes, let's just say, for the sake of I think you'd say it wouldn't make any difference whether they were claims under the treaty or
No,
not.
I agree. I don't think it makes any difference.
So
I don't think there's anything in 790 that makes any difference.
Even if there were withholding tax claims under 790 because there wasn't a treaty in place in the particular
It wouldn't make any
case that
difference.
didn't apply, you would still say it's the same point because it's a different claim even within 790.
Exactly, yeah, yes, definitely.
Yeah, well, I understand you say the result is the same either way, but nevertheless, from our perspective, we need to know which provisions we're supposed to be construing. And at the moment, it seems to me that the burden of your submission is that the relevant provisions are those in the double tax treaties,
If you're asking,
which we haven't even looked at yet.
if you haven't looked at, yes, but we will provide them tomorrow, I think now, for you. Exactly. Now, I think, and that's right as regards the position in 2000 and whatever it was when these claims were made in the return, they were being made under double tax treaties, and that must be the relevant point. I think my learner friend might say, well, the claims for FNR, which they're now regarding as being made, would be under the conforming interpretation of Section 790. I don't know. That may be.
That seems very bizarre. I don't get that at all, because
The
I
question is,
don't see how that converts a claim made under a treaty to a claim not made under a treaty.
which what we're construing is what happened in 2006 or whatever it was at that.
Well, at the
return letter,
moment,
not what
I mean,
happened.
obviously we won't hear what Mr. Bremner says in reply, but at the moment, it seems to me that you're correct, so that on its face, it's a claim under the treaties.
Well,
Yeah.
maybe I could just clarify, or you may need to clarify, whether under issue 3, we are in all cases dealing with withholding tax under treaties.
Yes, I'm not
Because
sure.
because
Yeah.
I didn't understand you to make that submission, and if you're not making that submission, we do need to think about
Can I-
withholding tax
Can I
under
put it this way?
790
In the
as well.
when this is the test claim or the leading claim for this issue. All of those seem to be under treaties. I can't tell you that all the followers who are behind this don't have any claims under 790. They may well have.
They do.
Quite likely, yes. So it may be for that reason, although there isn't one in the lead claim, it might be something that needs to be
Yeah,
dealt with for
but that gives rise to a difficulty, doesn't it? Because we don't have the documents for any such claim. So as I understand you accept, it's inherently probable that there may have been claims to unilateral relief under Section 790, but we don't have any documents to show how such claims were made.
Yes. No, I agree, and you can't come to any conclusion on the facts as to whether another particular claimant made a claim.
Yeah.
I mean, that may be why my learner friend's trying to keep this at a level of generality, of legal generality that would apply, I'm sure he would say, to everybody. Because if 790 has the effect, or the double tax treaties have the effect that these are all single claims for DTR, then that would apply to everybody, whatever they said, I would assume.
All right, where do we go next?
So I was going to take you next to the Upper Tribunal decision.
Well, is that something you can do briefly? I'm just wondering, I mean, how are you doing time-wise?
I'm perfectly fine time-wise. I've got.
Rather than starting to
Yeah.
get into your critique of the UT's reasoning, perhaps we'd better save that for tomorrow if you're doing well
Absolutely.
time-wise.
I just want to sound that when you're estimating time, I will have a number of questions on some of the more detailed issues that were dealt with very rapidly in opening
Absolutely.
towards the end of Mr. Bremner's submission. So please,
The afternoon.
if you're saying I've got plenty of time, please bear that in mind.
I will. But
Because there are quite a few issues there.
Yes.
that were-
no, I appreciate that. But having this afternoon is actually might help to. The more time you have, the less you can compress things. Oh, it's fine.
But my latest point is don't over compress your
No,
oral submissions.
I'll compress what I'm saying so that I can have some time to deal with the questions. No, I understand that.
Yeah, all right. And you don't think we need sit early tomorrow on that basis?
I don't think so. No.
Very good. So we'll resume at 10:30 tomorrow.
Authorise